Welcome to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. And now your hosts, Tim Kowal and Jeff Lewis.
Welcome, everyone. I am Jeff Lewis.
And I'm Tim Kowal. The California Appellate Law Podcast is a resource that Jeff and I put on for trial and appellate attorneys. Jeff and I are both appellate specialists, but we split our practices about evenly between trial and appellate courts. And in each episode, we try to bring some perspectives and news that practitioners can use in their practice.
And our podcast is sponsored by CaseText. A quick announcement about CaseText. It's a legal research tool that harnesses AI and a lightning-fast interface to help lawyers find case authority fast. I've been a subscriber since 2019, and I highly endorse the service. Listeners of our podcast can receive a 25% lifetime discount available to them if they sign up at casetext.com/calp. That's casetext.com/CALP.
And today we are very privileged to welcome the Honorable James Lambden to the show. Justice Lambden sat on the First District Court of Appeal in San Francisco for 17 years, authoring over 1,000 opinions and joining in hundreds of other published opinions authored by his colleagues. More than 100 of his opinions resolved important civil issues, and several of those resulted in new law, either by subsequent legislation or as affirmed precedents. Justice Lambden now serves as a mediator, arbitrator, discovery referee, and appellate consultant with ADR, and we are so pleased to have Justice Lambden join us on the show today. So welcome.
Thank you very much, Tim and Jeff, for inviting me. I'm very happy to be here.
And well, like I said, we're honored to have you. I wanted to start off just asking maybe some personal questions that I've learned about you by digging. There have been some pieces in the Daily Journal and the Recorder published about you, talking about how you're an avid outdoorsman for many years. And I wondered, even when you were on the bench, you were getting outdoors. Since you have left the bench, have you been able to liberate yourself more often from the city to get out into our beautiful exterior in California?
Well, we were talking about the mural that's behind me as being the Eastern Sierra. I have an early picture of me when I was a skinny freshman in high school on my first backpacking trip. I went backpacking every year more than once for almost 50 years. I think maybe more than 50 years. I very much enjoyed that. I hiked the John Muir Trail twice, once in pieces and once through hikes. I lost 18 pounds. I lost 3/4 of a pound a day during that hike.
And how long is that hike?
It was about 225 miles, and it took 21 days and a little bit extra. When my wife picked me up in Yosemite Valley, she took one look at me and burst into tears. I was surrounded by a group of tourists who were basically wondering what happened to that man. And it was one of the high points of my career in hiking. I hiked with several of my friends who were judges as well. And I continue to get outdoors, although I retired 10 years ago. And when I retired, I did take some of those more vigorous hikes, which were daunting. But now I get out several times a week for a good 5 miles, but I don't go to the altitude quite so much. But I still very much enjoy the outdoors.
Well, good. 5 miles at a stretch is a good number. I have small kids, so I use that as an excuse that that it would exceed their limit. So as a result, I've just gotten fat sitting in my chair. Well, and in addition to your career on the bench and your avocation in the outdoors, I also understand you're a man of many hats, literally, that you are a collector of hats that you used to display in your chambers.
Well, you must have seen that. I think it was a Daily Journal article, and the photographer who came was delighted to see all those hats and actually did a sort of a montage of all these hats floating in the air. I'm not sure exactly how it happened, but my baby pictures have me wearing hats. I had 7 uncles, and I was a late baby, so I was I got a lot of attention from my family. And one thing about hats is when people think you like hats, they give them to you. So at one point I had maybe 35 hats, most of which didn't fit me because people found that it was amusing to give me a 3-cornered hat with a feather on it, but it wouldn't fit me. Since I've retired, I have better hats, and I've done a couple of mock trials in New York, and I have a hat shop in New York that I frequent and treat myself whenever I go. I could lecture about hats. There's three places in the country where you can get hats: Chicago, New York, and St. Louis. And they sell their hats in Hollywood. So in California, you can find them in Hollywood as well. So we're talking about good hats, which are an indulgence.
Hat wearing is kind of a lost art in my generation. There's not a lot of hat wearing going on. What's the I know, and you're not wearing a hat today, for example. So what's the proper decorum for hat wearing?
Well, generally, you need to get one that doesn't come small, medium, and large. It needs to have numbers attached to it, and you need to know what your hat size is, and you need to spend some money on it. I mean, they're not inexpensive. One thing that I enjoyed was that when I retired and I got back out on the street in San Francisco, I would be walking along Market Street, and a middle-aged woman would come up to me and say, "Oh, it's so sweet to see you wearing a hat. My grandfather wore hats." That put me a little bit off because I was in the grandfather stage. But when I was coming up in the 60s, the only people that wore hats were young black men and old white men. And I kind of fit the second category. But I enjoy them a lot. It gets me a lot of attention.
And I heard a story, or I read about a story where you, I know John Eisenberg, or I know everyone knows of John Eisenberg in the appellate world, that you gave John Eisenberg a hat one time. Is that a true story? Is that?
I did indeed give John a hat. He's one of the few people that had a hat big enough that I could hand me down one. I have another good story in that the old Hawthorne Lane restaurant, I went in there one day with some of my colleagues wearing a hat. And when I came out, I gave them my ticket and they brought me Willie Brown's hat because he was apparently in the restaurant at the same time. And I teased Mayor Brown later, saying that his hat was way too small for me, which he thought was funny.
So are your best hats the ones that you buy for yourself or the ones that you've been given?
The ones I buy for myself,
because they fit.
The joke hats are not really very good. Somebody also let me try on their barrister's wig, which is sort of a hat. I don't have one of those, partly because they're horrendously expensive. They're antiques, and I don't think I need to invest in one of those.
Well, let's move on from hats and talk about your career on the bench, and now you're in private judging. Is there something? Can you tell us something about private judging that you enjoy, or that maybe surprised you as you transitioned from the bench? This was some time ago now that you transitioned, but now you've got advantage on both worlds.
Well, I like to say that I had all the best jobs that you can have in the legal profession. I was a partner at a great law firm, and I enjoyed being a trial judge very, very much. And the Court of Appeal is, I think, the best job in government you can have. You have resources, you've got help, you've got some influence, and nobody knows who you are for the most part. Your name is not in the paper, so you don't get as many death threats. And I was surprised at how much I enjoyed the private world, the alternative dispute resolution consulting work. Partly because I'd forgotten how gregarious I am. So I enjoyed seeing the people. There are a lot of people on the Court of Appeal, obviously, but they're the same people every day.
What do you mean you had forgotten how gregarious you are?
Well, because when I was in law in motion in Alameda County, I did the whole county in a master calendar. So I had about 30 cases a day. And during that time, the estimate is that I probably heard 25 to 30,000 cases. And during that period, all of the people that I ran into tended to be the younger attorneys who were given the job of going to law in motion. And when I came out, I found that they're all managing partners now. They're still practicing, and they're still happy to see me, and they remember me. So I discovered that I had many more friends that I hadn't seen in a long time. Working on the Court of Appeal is like working in a museum in a certain way. It's very comfortable and it's very quiet. So I was really happy to get back out among my lawyer friends again.
Yeah, you don't get as many opportunities to interact. So is oral argument at the Court of Appeal is not the same thing as interacting with counsel at Law in Motion.
Yeah, no, it's one day a month and or two maybe, and again, you kind of see the same people. I was always surprised that over half of the cases they would waive argument.
Really?
I would never do that. But I think at one point it was about 60% were waiving argument. Mostly those were the criminal. A lot of those were the criminal cases. I remember that we complained when the AG's office, which was located in the same building that we were in, would call and want to appear by telephone. And Justice Kline in particular said, well, at least you could come downstairs, okay? So I've always really enjoyed the arguments.
Yeah, is that or what would you say is something that you miss the most from the Court of Appeal? Was it the arguments or anything else?
Well, I certainly miss the people. You get very close to your staff in particular. Over the years, I have had, when I was on the trial court at one point, I had 7 research attorneys who reported to me.
Oh, wow.
And on the Court of Appeal, I always had no fewer than 3 and maybe an extra. And you get very close to those people. I mean, you really kind of sit around in the office and job with them a lot and get to know them very closely, along with your assistants that are on the staff. So I really miss the people. I did miss the time that you have. The thing about the Court of Appeal is that you finish the opinion when you say it's finished. Although, we have over the years heard some complaints about the delays. But having the time to reflect is really nice. On Law in Motion, it's kind of a shoot from the hip decision that you make, and I enjoyed that a lot too. Although it's very wearing to have that many cases a day and to try to do a good job on all those cases. Because like I said, I had 7 attorneys, and every afternoon after the calendar, we would line up on 2 couches with me in front and go down the line with them briefing me on the next day's cases. And that makes the time go by for sure.
I bet. When I was a young law student, I clerked for the DA's office doing preliminary hearings. And you'd show up in the morning and they'd hand you 10 files. All right, here are your preliminary hearings for the day as a certified law student. And you just never knew what it would be. It would just...
Well, I always told my law clerks, I had a lot of interns on the Court of Appeal. That's one thing I really enjoyed. And if you really want to be a trial lawyer, go to work for a public office, like a DA's office, because they'll hand you a dozen files and say, here, take care of these. And you will learn to talk on your feet pretty quickly.
Yeah, that's great advice. And you get in front of so many different judges when you're a certified law students that by the time you're graduate and you're ready to practice, you're no longer intimidated by certain personality types on the bench.
Well, I have another story there that it's a fairly small community. So when I came on the bench, I was the first civil lawyer in a long time to be appointed because of Duke Majan. He appointed a lot of prosecutors. And my very first felony calendar, I walked out to a packed courtroom. Every DA and PD in the building had come to see how Lambden performed that first day. And it was daunting. Then I got the flop sweats, actually. I actually had one of the defendants. They had the jury box filled with guys wearing orange suits. And one of them actually spoke up and said, aren't you supposed to remind him he has a right to a lawyer? I said, thank you. I appreciate that. I skipped that in my script. So that was a very steep learning curve, but I enjoyed doing criminal cases as well.
Wow.
Well, and you mentioned that one of the things you missed from the Court of Appeal are your colleagues. While you were at the First District Division II, you worked alongside Justice Anthony Kline, who had been Governor Jerry Brown's Legal Affairs Secretary, and you also worked alongside Justice Paul Hearle, who had been Governor Reagan's Appointments Secretary. There must be some stories there. Did the different perspectives represented on your panel produce better results? Did it produce friction, or a little of both?
Well, a little of both, but I think generally a very good result. Justice Hearle was certainly a more conservative justice, but he was also a gentleman and very willing to listen to different points of view. Justice Kline was rather famous for being opinionated, and there had been for a number of years sort of a revolving door in Division II in terms of people who moved on. And there were some famous feuds in Division II as well. But on balance, I think that we did a good job. The three of us. Later, we were joined by Justice Rubelo in getting along. A good example would be the very first cannabis case that was heard in California came to our division, and by the luck of the draw, it went to Justice Hearle, and we teased him a great deal about handling the first cannabis case, including giving him hemp stationery, and I can't remember what else we did for him. But it was a good example that although he was conservative, we got the right answer, and I was very proud of the result in that case and others as well. Another one that we had was the 101 California shooting, which came through our division, and we had elaborate discussions over how to deal with that case. And I think we ended up with 3 different opinions. I can't remember exactly. I know I wrote separately. So yes, I think we did a good job.
Now, there's been, as you were talking, it made me it reminded me that there's been a lot of ink recently as the governor has been looking to fill the Chief Justice slot on the Supreme Court, and there's been a lot of folks out there talking about opining about how collegial and how consistent the Supreme Court has been in our state, and in giving a lot of unanimous decisions despite even controversial issues. And one of the more common explanations is that, well, maybe all the justices are more or less ideologically aligned. They're all tend to be slightly left of center. That explanation doesn't quite seem to match up with your panel with Justices Kline and Hearle. It seems like you were able, and yet during your 17 years on the bench, you never filed a dissenting opinion. So you obviously had very good collegiality, produced a lot of unanimous opinions. So what was the secret sauce there?
Well, I think you've pointed out the exact point, which is that I always tried to mediate between my 2 colleagues, and I didn't write any. I did actually write one dissent. I'll tell you about that in a minute. It was unpublished, but I was in the catbird seat. I mean, generally, I was going to be the deciding vote if there was a big disagreement. So my effort was to try as best I could to achieve a unanimous decision. If I could negotiate the language of an opinion that everybody signed, I was very, very proud to do that. Now, I did write one dissenting opinion, and I think I teased my friend Justice Rubelo that it was only to him, and it involved some ridiculous dispute over trees that were cut down by a homeowners association. And I was convinced that he got it wrong. But it wasn't necessary for me to dissent generally. And we wrote some very good opinions, I think, for that reason.
You mentioned the opinion over cutting down trees. I've had those kinds of cases, and I hear about those kinds of cases. And Jeff and I have talked about in another episode about how the Court of Appeal has has a wide panoply of cases that it has to decide. Many have very grave ramifications. There are death penalty cases, or people with life without parole. There are custody cases involving parents' rights to over their children, and then we have cases about whether you should have cut down my tree or not. And I wonder if that factors in. You get those those cases sometimes, and say, another one.
Well, one thing that is really enjoyable, going back again to when I was on the on the trial court in Law in Motion, I was kind of on the bubble, because if I read something in the Chronicle or the East Bay papers on Thursday, I might well have an ex parte application on Friday relating to that. And one thing, you mentioned trees. Berkeley in particular is tree central for tree lawsuits. So I got a lot of those on the court. And then you also find on the Court of Appeal that you see the trends as well. If you go to the old, any of the old digests, you'll discover that there's a huge number of cases involving ladders, trees, and fences, because that's what people get involved in their neighborhoods. And then on the other end, you get big questions of policy, and the really enjoyable work on the Court of Appeal is to get a really great policy question that you get to think about and argue with your friends about and maybe influence. I mentioned the California shooting, the 101 California shooting. That was one that allowed us to debate at great length what gun control could look like, and this was 20 years ago, more than that. Another thing that people don't particularly realize is that we give up our First Amendment rights to go on the court. Essentially, you can't go around talking and advocating, and you should not. For example, I was never a member of the Sierra Club because their cases would come in front of me, even though I'm an avid outdoorsman. But a good story on the other side would be that I wrote an opinion overturning the divorce settlement of Barry Bonds, which you may recall, which was a little bit off the ranch because we interpreted strict scrutiny into a statute in order to overturn his divorce settlement, promptly reversed by the Supreme Court. But I took a copy of the opinion that I wrote and wrote FYI on it and sent it to somebody in the state Senate, and the law was changed. Another example of that would have been in the 101 California suit. At the time, I wrote a concurring opinion pointing out that the legislature had passed a civil code section that said that manufacturers of firearms cannot be held liable, period. And once again, I took a copy of our opinion in that case, which was the result that we were forced to reach. And I sent a copy of that to the Speaker of the House, or the Speaker of the Assembly at that time, Don Barada, and that code section was rescinded. So, and that's not advocacy, that's just for your information legislature, and we have the ability to comment on the law, which is important.
No, that's interesting because we lawyers see that from time to time in the opinions where we'll conclude there will be a topic about the separation of powers that, well, while we sympathize with the appellant, this is a policy proposal that only the legislature can make, and we're not a legislature. So but we suggest that the legislature take a look at this next time it's in session, that sort of thing. Whenever we lawyers see that, should we, is it safe to assume that maybe the author of that opinion is sending a copy up to the legislature?
Well, possibly, because like I say, it is part of our job to educate and bring attention to that. When I was on the law, when I was in Law in Motion, I would frequently tap on the microphone for the reporting transcript and say, Court of Appeal, this is an interesting issue. And the lawyers in the audience always like that. And occasionally they listen as well.
I've never heard that done, but that's I like that idea. You can punctuate the record that way.
Yeah, no, I often encourage people to appeal me, more than once, saying this deserves an opinion. One thing that I run across now as a rent-a-rabbi in the evaluation world is that there are areas where people will make arguments, and they'll say there's no authority, and the answer is, well, nobody ever brought it up, and there should be an opinion on this, or it wasn't needed because you're wrong. It's so obvious that you're not going to find authority because nobody's ever going to bother to appeal it.
You're so obviously wrong, or you're just brilliant and no one understands.
Yeah, and by all means, if we can't settle it today, go ahead and file your appeal.
Right. Now, I just wanted to go back to one thing that you mentioned about that you were in the catbird seat when you're on your panel with with your colleagues. And I wonder if that can translate into any practical advice to practitioners who they're drafting their arguments and their appellate briefs, and maybe they're envisioning their panel maybe they got one vote to reverse, one vote to affirm, and then there's someone like Justice Lambden in the catbird seat. Is there something that you can use to kind of modulate your arguments to appeal to that middling position?
Yeah, well, educate yourself, because sticking with that point, I often had the feeling that I was being spoken to in the arguments because they might, in the particular case, think I was going to be the deciding vote. But I advise people when I'm doing appellate consultations to try to figure out who's going to write this opinion. I still know most of the people on the Court of Appeal, and even the ones I didn't work with. So when I'm consulting, the very first thing I want to try to do is to figure out who we think is going to write this, and what their predilections will be, and who might be the person that's going to argue with the author as well. It's kind of hard to do, and it's one of the things that an appellate ADR consultant can do, because we've been in that before. When we were still appearing in person, one thing that I enjoyed doing was showing up at the arguments, because they know that you're sitting out there and they pretty much know why you're there, because you've been involved in the case. You may remember that when Justice Kolke retired from the 3rd District, he got a little bit of a stir because he showed up as an advocate, like in the same court, within a month or two, which was noticed. Nothing wrong with it, but I can't remember the case, but it was obviously designed to be influential.
Yeah, we have the same thing happening in the 9th Circuit with former Judge Kaczynski. Former Chief Judge Kaczynski is now a practitioner in that court.
Yeah, I've got a lot of Kaczynski stories, but I probably won't tell you most of those, because he's a very interesting fellow.
Maybe after the red light goes off, I'll ask you again. Now, you've described yourself as a judge as being an academic judge, and that you're trying to get the right answer. And I wondered if you could just elaborate on that a little bit. Are there different schools of thought on that point? I would think that all judges are trying to get to the right answer, but I wonder what you had in mind.
I think if I had to restate that, I would say that I'm a process judge. I once described myself to one of my colleagues as that our position is a guardian of due process. One of my colleagues was a federal judge who was confronted in a country store somewhere, and they sort of braced him, saying, "Well, are you one of them liberal judges?" And his response was that, well, if Congress passes what you consider to be a liberal law, I'll enforce it. And if they pass a conservative law, I'll enforce that. So I think we, as I mentioned earlier, we give up our First Amendment rights to some extent. And the pledge is that we will, stay within the lines and try to make sure that the process itself protects the law. Even if we may disagree with the result that we reach. And I've disagreed with a lot of the opinions, or a lot of the results that I have reached personally, but the law is the law.
What about your work in private judging? Do you see your role as being the same? Is it following a process, or is it trying to get a right result if those two things are different? Or is it a different kind of animal?
Well, one reason I enjoy it is that it's very much a different kind of animal, and it's more directly applicable to the problem. The legal process is opaque to most people, except for the lawyers. And the fact that I get to educate and advocate directly to the parties is, and it's required because they're the ones that are deciding what they're going to do with their case. They're all surprised to hear when I tell them that my entire career of almost 50 years, more than 95% of the cases that are filed in the court settle. And they're shocked by that. They assume that it all goes to trial. No, it doesn't. And one of the things that I'm enjoying about this private practice is that there's a growing realization, particularly post-COVID, that litigation is not like preparing for a battle. It's more like going on an expedition. It's more like taking a trip across the mountains and encountering different places where you have to do different things. And I'm seeing that lawyers are beginning to appreciate that more, so that you don't sit down and just think, well, I'll threaten the other guy that I'm going to go to trial and I'm going to win. And well, but that's really not what the process is going to achieve if that's your attitude. So I've always advocated against going away from the sort of chest beating, threatening, beat you in court kind of approach to being as collaborative as you can, that you've got two clients that aren't getting along and have a dispute and you need to help them resolve it. So I think that the new paradigm now is much more shifting in that direction. I can feel it, partly because the courts are appreciating it. They're appreciating that managing the calendar rather than simply calling the case and trying it is a much better way to resolve the disputes, basically recognizing that most suits should settle.
Yeah. But what do you mean that you said you see things shifting? What has changed? I mean, I very much like that observation that litigation's not a battle; it's more like an expedition. Because in my experience, it feels like at the beginning of a case, you only know what your client has told you, and maybe you've done a little bit of independent investigation just to satisfy your 128.7 obligations. Right. But usually, by the time you get to trial, you're looking back at your complaint and you think, "Gosh, if I only knew then what I know now."
Well, I advocate an early, not evaluation with a mediator, but an early evaluation of your case by recognizing those signposts along the way where things will occur. A good example, though, is an early mediation, where the complaint is filed and you call up the other side and beat your chest and said how powerful and what a great attorney you are. And then decide what comes next. Is frequently useful to decide, well, let's do the P&K, the person most qualified deposition right now, and then let's talk to a mediator. Or alternatively, let's start thinking about what discovery is going to be like. If you've got a case that has 1 million items of electronically scored information, you should be able to recognize that's going to be a problem. And that the other side is going to object to everything and you're going to object to everything. So think about how you're going to manage that, because you are going to manage it. And no matter how many times you go to court and shout at each other over somebody not answering or answering ineffectively, you're still going to have to give over the information. So another thing that I'm seeing more from the courts are references for discovery. I'm doing a lot of that now. And in the old days, there was a reluctance to do that because of the expense to the parties and the feeling that you were sort of putting people off to somebody else. Plenty of authority now that you can't just assign your discovery calendar to a referee, but you can assign the management of discovery to a referee, and ultimately it may be cheaper for the parties to not have to reserve a date, go in and yell at each other for each problem they arise. So when I'm doing a reference, for example, we have an initial meeting where I'm kind of mediating. I'm saying, what are your beefs going to be like? What do you think is going to happen with all of this ESI? How is it going to be managed? And then regular conferences that are reported to the court about what's going on. Now, the judges in court love it, really. I think that's something that's really changed. Rather than being reluctant to get help outside the court, now they're seeing what a boon it can be in terms of not just putting the work on somebody else, but actually making the case get settled and get moving forward. Yeah.
Plus, judges famously hate discovery disputes.
Yeah. Well, and another example would be, and this comes up in a mediation where I'm talking to the parties. It's a business dispute. Let's say the one issue is going to be the value of the stock that there are. So you can either stipulate or get the court to appoint an accountant who will decide that issue and present it, and the case will settle once you got that number. And I've done some arbitrations like that where they brought me just one issue decide whether or not this agreement for purchase and sale of stock is enforceable. Once they get that answer, it's done.
So we talked about evaluating cases like pre-trial and in terms of discovery. How about in terms of appeals and post-trial? Is the best time to get a neutral involved immediately after the adverse verdict when emotions are running hot and someone's thinking about appealing, or maybe a year later when appellate briefs are about ready to be written? When's the best time to get a neutral evaluation of a possible appeal?
Well, one thing you mentioned, that in the right case that needs it and you can afford it, you should hire your appellate lawyer before the verdict. That's number one. And then secondly, appellate mediations are difficult because somebody's already won. And that generally means that they're going to try to bring it to me, for example, to tell them who's going to win the appeal. And that's not particularly useful because I can't just say, I think the court was wrong, give them the money, because they're not going to like that answer. But you can, evaluate in the right case a better result. And that's where the evaluation of an appeal with a mock trial may be useful, to write the briefs as well, to say, not only here's how your argument can be improved, but this is the issue that's really going to matter. And this is the one that they may or may not publish on. We have done, in my office, focus groups. We have a number of retired justices. So we've actually had cases where they've been large enough that they've hired maybe 2 or 3 panels of multiple justices.
Wow.
to hear and then vote on what you think the result's going to be, and they pay attention to that.
Well, let me ask that. I've got buddies from law school who I've done moot courts with in advance of appeals. What can a retired justice offer, or a group of retired justices offer in a mock argument that my law school pals can't?
Well, it depends. I would say that some of my, there's a wide variety of how good that experience can be. One thing I would suggest is, if you're going to bring a mock trial, find one of your law school buddies to play the other side, and get somebody that will do a good job. And then make sure that you get justices who will engage. Many of the oral arguments on the Court of Appeal are not particularly engaged. But get people who will really take it seriously in terms of not acting like they used to on the bench, but actually being interested in your problem. And that's helpful in that regard. It's helpful if you bring us in to talk about the case when you're writing the briefs, when you're putting it together. So the typical consultation for me, it starts at that point. Maybe the appellate brief is in file and the respondent wants to help draft the reply. And if we're engaged at each stage of the appellate opening brief, the response, and then the reply, it's pretty easy to direct people in the direction of where you think the argument's going to go, particularly if you're forewarned in some fashion by knowing who the panel is.
Yeah. All right. So you shared some best practices in terms of things to make sure you do in connection with a mock trial. I wonder whether it's mediation or evaluation post-trial, are there any pet peeves or things that lawyers should avoid doing to make sure they get the best value out of an evaluation or a mock trial?
Well, generally, it's a good idea to practice your elevator speech on what the script is. Too much information is not helpful. Frequently they'll send, even in a non-appellate case, they'll send their whole file. Read all my briefs that I've filed in this case. And that's not particularly helpful. The thing that's most useful is to focus on what's going to be important. And I observed that when I was a trial judge as well. I get to the day of trial and it occurs to me, these people don't really have a theory of their case. They haven't really figured out what they're going to argue here. So you need to regard it as a narrative from the beginning and write your script accordingly. And then when you get to somebody that you're paying a lot of money to evaluate, make sure that you're bringing up the points that are pertinent. or ask which points are going to be pertinent. But that's the point of having somebody evaluate. And there's been a real shift that everybody recognizes now from sort of the sociological approach to mediations to the evaluation approach, which doesn't mean come in, you arrive and you say, Judge, evaluate this and tell them to pay me. It means that you'll actually talk about what's going to happen and what the moving parts are, which aren't all legal and aren't all money. A lot of times it's mother always liked you best, or I hate my brother-in-law. And that's one of the things that's much more interesting and enjoyable in court is dealing with the people part of it.
That's what you refer to as the sociological part of the case?
Well, originally the mediation work came from sociological studies about sort of getting people to recognize their own interests and get it off their chest and cause them to have some sort of a kumbaya moment where everybody shakes hands and says, oh, we didn't mean it, we'll settle. Everybody realizes that that's interesting, but it's not really how it works in the hurly-burly of the legal world and litigation, but it's still a factor. So I expected, because of taking some mediation courses, that there would be a lot more of this sort of warm and fuzzy stuff about trying to find out how people are feeling about their opponents. It's pretty easy. Usually they're mad at their opponents. You walk in the door and they know that somebody's either suing them or they're being sued, so they're pissed off. I kind of refer that as the fortress mentality, that everybody hunkers down behind their battlements and says, we're going to win this battle, and assumes positions without really thinking about what that means in terms of a 2-year court delay to get a trial, the amount of money they're going to spend on their lawyers, and what their hard feelings are worth to them in the real world. So that part I still enjoy very much, but it's kind of sub rosa behind the legal discussions.
Yeah, as you talk, I hear you talking, touching on a lot of themes that I could describe as theory of mediation, and different. It's a different skill set, or it's a distinct skill set from the skill set you practice as being a jurist. And I wonder, was the transition to adapting and utilizing this mediation skill set, was that natural, or did that take some time to learn these? Or did this all come from being on the job training, being a Superior Court judge and then a Court of Appeal justice?
Well, some of each. A lot of my colleagues, both trial judges and appellate justices, kind of find the transition to be difficult. The sort of going back out among the bar without wearing the robe is kind of intimidating. Like they say, that they don't laugh at my jokes anymore. So there's that. And then there's also the situation where the instinct is to be very evaluated right off the bat. Say, I've read your briefs, you're going to win, pay them. And that won't work. Also, judges are sort of taken aback to discover that they're now working for the lawyers. Really, we are. The lawyers pick the mediators and arbitrators, and that can be a little intimidating. But my background was such, also in terms of what I did as extracurricular activities on the Court of Appeal, was that I was more open to being out among the people and paying attention to their non-legal questions and non-legal interests. And I've always, I always thought I would end up being a professor because I really like educating people. Turns out that I can do that and get paid much better than I would if I was a professor. So I'm doing that now. So that part I enjoyed a lot. And as I said earlier, being able to talk directly to the people who are the stakeholders and answer their questions is very, very enjoyable.
Well, you mentioned about the elevator pitch problem. We talk about a lot as the throwing the spaghetti at the wall problem, when you don't have a theory of the case and you're just going to throw all your arguments out there. And it made me think back to from your time on the bench. Are there some best practices that you can share with our audience about brief writing grab the court's attention. I take it the same advice would apply there. Don't throw all the spaghetti at the wall. Do a lot of attorneys have trouble learning that lesson?
Well, one thing that I love about attorneys, and one thing that annoys me, is that they're so thorough. That the one thing that an attorney fears more than being buried alive is missing something. So think about the bar exam. It's all about recognizing issues. So that thoroughness leads to overwriting generally and over arguing generally. When I was on the law and motion bench, I frequently would raise my hand and say, okay, you're running the loop again, and you don't need to do that. I heard the argument the first time. Another thing that I used to say is somebody had told me that I could have written a shorter brief, but I didn't have enough time because it takes more time to write succinctly than it does to write to the point. So not giving up an issue, I think I used to say on the Court of Appeal, there's nothing stronger than conceding an issue. To say, all right, Your Honor, I know that issue is not my strongest point. Let me tell you what my strongest point is.
But that goes against all of our training.
Exactly. And it takes courage. It takes courage to do that because your client doesn't like to hear that, for one thing. You know, your clients pay by the inch for the briefs and they want it to be thorough.
Right.
But
what's the advantage of conceding a point? What does that buy the attorney?
It buys you credibility in the Court of Appeal. To argue a point that's clearly not the most important point, and you've got 15 minutes to make your argument, is just a waste of time. And we always noticed when somebody would say, you know, I'm not going to talk about that, I'm going to talk about this. And that's what's strong about it. And it takes the courage of your convictions, knowing what your case is about, and not simply being ultra thorough. I would say too that I will mention one other pet peeve. I suppose it's a pet peeve. Would be the I don't know what you'd call it, the battle theory that I'm not going to answer any of your questions. You're not going to get any cooperation out of me ever on anything. I'm going to fight you tooth and nail right to the courthouse steps in front of the jury. I still run across attorneys that behave that way, and it's always annoyed me, but it's also at counter purposes with what their job is. And I think we've all observed there are a sizable percentage of attorneys who get along pretty well just by being unpleasant. You can settle cases with you can recognize cases that'll settle just because I'm tired of dealing with that guy. So I always encourage people to remember to show not compassion, but allow your opponent to save face. You don't need to grind their heel on the fact that they've lost their emotion.
I wanted to ask you about something that I was thinking about recently, about one of the differences between the California state appellate system and the federal system is that in the California state system, we don't have horizontal stare decisis, meaning that a court of appeal in California can look at another district court of appeal opinion as persuasive or not. If the court is not inclined to agree with that holding, it can treat it as if it doesn't exist. And I wondered if you thought from your time on the bench that this makes a big difference or a small difference in your work as a justice deciding the cases. Is this something that practitioners ought to keep in mind?
Well, there's a parallel question there, and that is the perennial fight over whether or not you can cite unpublished cases, which are available to everybody. And it's an ill-kept secret that a court of appeal justice can look at an unpublished case and like the reasoning of it and find a way to put it in an opinion. You make me think of a recent arbitration that I did, where I actually put a footnote in pointing out that if you read the Monchar's decision from the Supreme Court that Justice Lucas wrote, if you read that carefully, it essentially says that an arbitrator can look at anything. You're not going to have an appeal on it. You're not limited to published opinions. So I think I might have shocked the parties, because I had this arbitration where both sides were arguing at great length unpublished opinions and complaining that the other guy shouldn't be allowed to cite them. And of course, I found all of them very persuasive, and wrote an opinion that way. So you can always find a way to get the reasoning into the case. And as I would admit that a Court of Appeal justice will do that and adopt the reasoning of a case. So I think that happens in all the court systems. It's not, once again, it's not a big community, so we know what other people have said.
Yeah, no, that's a good thought. I mean, the point that a lawyer may not cite an unpublished decision, but that practitioner could still copy and paste the language, that reasoning, make the same argument, and it has as much binding authority. The reasoning has as much binding authority as another published District Court of Appeal opinion, in that it doesn't have any binding authority. It's what the Court of Appeal decides it finds persuasive or not.
Well, and I can't give you any citations. One thing I loved about my friend Justice Kline is that he could give you the citation for every case he ever wrote, which is interesting. But if I had some time to study it, I could show you some appellate opinions that contain the reasoning of unpublished opinions, which then makes them published, which is the way it works. So the right answer is where you find it.
Yeah, that's right. Let me ask you this question. Most appellate attorneys that we talk to would love it if the court were to issue more tentative opinions or focus letters. And your division's practice, when you're on the bench, was to issue focus letters before oral argument, which would tell the advocates what issues the panel was particularly interested in hearing about during oral argument. What was your experience like with these focus letters? Was it positive?
Yeah, it was definitely. And I'll go back a little further to say that I wasn't the midwife for the idea of tentative rulings, but I was there at the birth. And the idea on the trial court was that you didn't make people come to court. You put it on the phone line what the ruling was, and they wouldn't show up. But on my trial bench, I most frequently used it to say, parties appear. I want to hear your argument on this point. And I would say, parties appear, and I'm interested in this. And they would show up. And that carried over to the Court of Appeal. On the Court of Appeal, originally, when I started, the idea was, well, if we give them a tentative ruling, they're just going to come and argue with us and tell us we're wrong. And we've already written the opinion, so we don't want to hear it. So the compromise was really the focus letter, which is kind of like saying parties to appear. We want, this is what we want to hear about. And it also avoids that concession problem I discussed, where there are some issues that aren't going to be important to us. So I think it worked really well. I know that some of the divisions, I think in the first district, are now posting their drafts, which was done in the fourth district for many years. And I have no objection to that either, but I think the focus letter makes the argument better, because you're actually saying this is what we're interested in, rather than here's the draft, and once again you can come and argue with us and tell us we're wrong, which is not really as helpful. It comes from my actually thinking that oral argument is important, which is, as I said, surprises me that so many people waive it. And it may be appropriate in routine cases, but on the other hand, if it's worth appealing, I think I'd like to talk about it.
Well, on that subject, your division did not have, I wasn't aware of this, your division did not have time limits on oral argument. You had said at one point that we just let you talk until you're not interested anymore. And I wondered if maybe the corollary to that is at some point the panel probably is no longer interested. How do lawyers get the hint that they ought to stop talking?
Well, we would let you know, obviously. We never, in all my years on the Court of Appeal, we never used the lights that light up and say you're done. But you make me think of an interesting story where it was turned back on us. The late Dennis Reardon, who passed away very recently, was a real favorite of ours. And I can remember a day in an oral argument where he had his notes and he was arguing at great length and became frustrated and closed his folder and said, well, if you guys don't get it, I'm done, and sat down. And we all laughed uproariously, actually, and it was very amusing, and it was very Dennis as well.
Yeah.
So we were never. I can remember running well into the lunch hour if we found both attorneys with an issue that mattered, talking, very well about the particular issues. And we often would set our calendar that way. If we had a case where we were really arguing about the result, we'd put it last and we could run into lunch. Because I think all of us enjoyed argument.
Did any attorneys abuse the privilege and just drone on and on and on, even though the bench may have been cold?
No, we wouldn't let them do that. When you're done, you're done. I should say too that another thing about being with Hearle and Kline was that I think I was actually presiding judge at oral argument maybe 2 or 3 times in 17 years, and a couple of those were when I was pro temping in a different division, because one of them was always there.
Yeah. Because
the only person that served longer with Kline was Hearle by about 6 months. And as I like to say, I did a 17-year sentence with Kline.
Well, I wanted to conclude by talking about your work on access to justice more broadly, and I know this has been part of your life's work since 1997. You were first a founding member and then chairman, and now an ex officio member of the California Commission on Access to Justice. You served on the board of the National Consortium on Racial and Ethnic Fairness. For 9 years, you chaired the Access and Fairness Advisory Committee of the California Judicial Council. And in 2013, you received the Benjamin Aranda Award for your lifelong work to removing barriers to access to justice. And you've talked before about how your sister's hearing loss initially spurred your interest in helping the deaf and blind to gain better access to justice. So when you started this journey 25 years ago in your work on access to justice, what were the resources like and how have they improved?
Well, there wasn't much. When I was a young lawyer, because of my sister, and also because my firm had clients who were deaf. The California School for the Deaf was in Berkeley at that time. I was really struck with the fact that if you're deaf in the courtroom, you're excluded. You're completely excluded. You have nothing. You don't know what's going on. Basically, one of my very first projects was to get the Bar Association referral line put on a TDY so that deaf people could actually get a lawyer. And once you open that door and you see the barriers to justice the first time, you see them everywhere. And when I started working for the court, you remember those signs? You may be too young to remember. There was a sign on every clerk's desk that said, "We're not allowed to give legal advice. Go away." Basically. So something as simple as, "Where do I file this?" They would frequently say, "Well, we don't have to tell you." And we got rid of those. I was lucky when I came on the Court of Appeal in particular because I followed the appointment of Justice George. And he very much agreed that without access, there is no justice. So that was really kind of the golden age of really pushing on the issues of the fact that many people are excluded, whether by language, whether by their hearing impairments, disabilities, or really anything else like that. If they're not allowed to get into the court, that's a problem. And it still goes on, obviously. And it's been one of the big rewards of my career to be able to work on some of that stuff. I'll tell you, I know that you'd like to hear one more story. One was that when I was working on all those committees, both the State Bar and the Supreme Court Committee, we tried for years to get a budget line item in the California budget for legal services, to fund legal services at the community level. We proposed it 1 year before Governor Schwarzenegger, and he didn't sign it. We proposed it the next year, and he didn't sign it. The third year, we changed the title of it to the Sergeant Shriver Access issue. And we always believed that Maria Shriver probably had a little influence on the governor because he signed it. And it was the first time that California had ever actually funded legal services at the level. And it's been a line item ever since. And I think we're somewhere north of $400 million it's been spent on legal services. So a very proud result.
That's a great result. Let me ask you a related question. When I first started practicing law 26 years ago, when I showed up at a courtroom, anywhere I went, there was always a court reporter. For the last 5-10 years, there has not been court reporters in civil departments. And this past month in LA, they just announced that in family law, probate, writs and receivers, and the departments that handle restraining orders for domestic violence, none of those are going to have court reporters anymore. And the presiding justice for LA announced that it's not a problem of compensation. There's just not enough court reporters out there to show up and do the work. And I wonder if you had any thoughts from your years on the bench about this court reporting crisis and access to justice and where this is going to end up.
Well, it's interesting because when I came on the bench in the late 80s, everybody was all excited about the possibility of electronic records. And we actually, my first courtroom had been outfitted with recording devices and cameras. Nobody ever really thought about the question, is the Court of Appeal, are they going to watch the film or are you going to transcribe it? And if you're going to transcribe it, that's a court report. So rapidly, everybody realized that court reporters, I used to prefer to call them word processing technicians or something, or communication director or something like that, because they did way more than simply transcribing. Good example would be the deaf question again. My court reporter was the first one in Alameda County to have a real-time reporting screen on her computer. So I got all the deaf cases because they could come in and they could read what was going on the screen. So the technology has improved, but you still need someone to do the work. So I think court reporters now, I still get a lot of them, even in my Zoom calls, are adroit at running the equipment, at figuring out how to make sure that everybody's on the Zoom call and that sort of stuff. A lot of the work that I do now in arbitrations, I have court reporters out of state. It's similar also with interpreters. We get a lot of out-of-state interpreters because they're all over the place. So that's another good way to wrap up the comment I made earlier about how there is a paradigm change. We haven't really felt it yet, but remote access is really changing the landscape in a good way, I think. And it's been a long time since I was trying to argue in front of the Judicial Council to say that we should allow video arraignments rather than putting the poor guys on a bus at 3 a.m. and driving them across San Diego County for 4 hours so that they can stand up and say not guilty. So looking back over my career to when we were having arguments about whether or not that was a good idea, everybody thinks it's a good idea now. And the clients think it's a good idea now in civil cases. And once that happens, things change very quickly.
I think I love your comments on that. Earlier in the discussion, you mentioned how you saw yourself as a process judge. You saw the one of the important roles of a judge is to afford a fair process to litigants, and I think that really dovetails exactly with your work on access to justice, because it's about affording an opportunity to everyone in our state an opportunity to be part of that process. Whatever the outcome is, that's going to be dictated by the law, and sometimes forces out, beyond the robe that you're wearing. But your job is to afford that process, and it's hard to do that if not everyone has access to it. So I know you've mentioned that access to justice is your one exception to not being ideological about things, and I think that is a worthy exception to allow. And I thank you for your time, Justice Lambden, although I do have to ask you to indulge us in just a few more minutes so that we can run a very quick lightning round today to ask. Jeff has got some doozies to ask you for the benefit of our listeners who have come to expect this from our show.
Is there a buzzer or something that I have to press for the lightning round?
You have to wait until Jeff finishes the question before giving your answer.
Well, that may be hard. Go ahead.
A little twist on this. Most of our guests are appellate nerds and have strong opinions about fonts and spacing. We're not going to be asking you what you prefer to use in terms of when you write, but we're going to be asking you what you prefer to see when you are on the bench or as a neutral, in terms of making something the most readable or persuasive. So a little twist on the lightning round. So here we go. Do you have a preference regarding fonts like Century Schoolbook, Garamond, or anything else when you're reading a brief?
I use Times New Roman, and there's something about that that's a little classic to me, and I like that. The main thing is to make it big enough for me to see, and the court rules take care of that, and the word count takes care of that as well too. In my career, I've seen every trick in the book to get extra words in, and you've already heard how I feel about writing too much. So keep it short, keep it so I can see it,
and don't skimp on the font size.
Yeah. Well, and I should mention too, if you're able to do hyperlinks, we love those, or I love those, and more people are doing them.
Yeah, that was my next question, actually. Briefs with either hyperlinks to the record or to cases. Do you find it helpful or distracting?
Absolutely helpful. Older judges and justices have a rep for being not particularly technological, but those of us who have bought into it, we love it. It makes it much easier to work on.
All right, fantastic. And then in an opening brief, oftentimes there's an introduction or a summary of argument. When you were on the bench, did you prefer that there be citations to every statement in that argument or in that summary of argument? Or is it okay to kind of skip the citations in that summary?
Not in the introduction. The introduction should be your elevator speech, and we've talked about that. And I like to have the elevator speech at the beginning, roll all the way back to the concluding paragraph. So the citations go in the middle, but tell me what your problem is up front. When I was on the trial bench, I used to tell people to use the ass backwards system. Write the order first. Write the order that you want me to make before you make your argument. Don't jump right in on the argument, because you need to know what you're asking me before you start.
I think that's great advice.
All right. And then final question of the lightning round. When you were reading briefs on the bench in terms of main arguments, all capital letters or initial capitals or sentence case, did you have a preference in terms of your eyes or what made it more readable?
Well, the points and authorities aspect where the point is made. I think any sort of emphasis on the point and making sure that it's short, whether you underline it, or make it bold. Maybe bold is going a little too far. Italicizing would definitely be going too far because it's a little harder to read italics. Yeah. But make those points stick out. I would also mention that I'm a big fan of bullet points, and I think most of my colleagues are. Some might be annoyed in a brief, but in the kind of briefs that I get in my work now, I like bullet points a lot. So if you can think of them in terms of being bullets that are a little bigger that have authorities, that's fine.
All right. And how about in terms of readability, either while you're on the bench or today in private practice, 2 spaces or 1 after a period?
I go with 2, but and I think that maybe is a little bit more readable. Obviously, we used to have arguments about that. There are no rules for commas, but try to make your sentences, assemble your sentences without a lot of commas. Because if you've got a lot of commas, it probably means you got a lot of clauses. And a lot of clauses is not a good thing. Sentences should be direct. And paragraphs. Paragraphs should start with a topic, fill in the examples, and end with a conclusion. And people kind of lose that. Everybody knows string sites are not necessarily good. You're not going to want to do those. One thing we enjoyed on the bench when we were able to bring our computers up is to pull a case out of the middle of the string site and ask them about it. Once again, keep it short and keep it to the point.
Yeah, my staff knows I don't really know how to use commas. I think I'm a pretty good writer, but I don't know how to use commas. So generally, when I'm editing briefs, I just rip to shreds any sentences that have commas.
There is no rule. I'd recommend that book you probably heard. It's called Eat, Shoots, and Leaves.
Yeah, right, right. All right. Well, you have survived our very first Justice edition of the Lightning Round. So congratulations, and well done. Well done.
Well, I appreciate you inviting me, and I hope you'll have me again. I've obviously got a lot of opinions about the work that I've done in the past and what I'm doing now.
Oh, we're going to invite you back to talk about the cases where unpublished decisions were transformed or cited into published decisions. So we're going to hold you to that.
I'll prepare by having my footnote from the Monchar's decision, sort of summarizing what Justice Lucas said, which is kind of, anything goes, a fair result, which I think is interesting when you're talking about arbitration.
All right. Well, we always love a good example of how to get around the rule against citing unpublished opinions. So that will go in the annals. So that wraps up this episode. And again, we want to thank our sponsor, Case Text, for sponsoring the podcast. Each week when we publish the episode, we include show notes with cases that we discuss, and we use Case Text for those links. Listeners to the podcast can find a 25% discount available to them if they sign up to Case Text at casetext.com/CALP.
And if you have suggestions for future episodes, please email us at info@cowalpodcast.com. And in our upcoming episodes, look for tips on how to lay the groundwork for an appeal when preparing for trial.
See you next time.
Thank you very much.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.